Good evening to all. Welcome to the today's CPE program on appeals and drafting. We heartily welcome today's speaker, Advocate G Janane and Abinov Vaidyanathan. Please rise to the photos. Happy to introduce today's speaker, Advocate Janane. She is a practicing advocate primarily in the Madras High Court, enrolled in the year 2013 in the Bar Council of Madras, Chennai, joined in the litigation office of a senior counsel, Mr. Rajagopalan, in the year 2013. She became the Additional Solicitor General of India in the year 2014 and continued to hold the post till 2020. She was associated with the office of ASGI between the years 2014 and 2019. She has handled the matters relating all types of law, civil and criminal representing for the central government. She was also handling private matters and appeared before small causes court, city civil courts, tribunals, economic offence courts, etc. She joined Lakshmi Kumaran and Sridhar attorneys in the year 2019, and she has been a part of direct tax team since then, handling primarily litigation matters at all levels starting from the AO to MC. She has also been appealing before other jurisdictional high courts such as High Court of Andhra Pradesh, Telangana, Kerala involving tax matters. And also I am introducing Advocate Abinov Vaidyanathan, graduated from Shastra University School of Law in the year 2019. He enrolled with the Bar Council of Tamil Nadu in the year 2019, joined in Lakshmi Kumaran and Sridhar attorneys in the year 2019, and has been part of the direct tax and economic offences team. He has been handling advisory and litigation matters with respect to income tax and FEMA. He also appears in income tax matters at all levels starting from assessing officer to Honorable High Court. So welcome to the speakers. Over to speakers. I would like to request C.S. Sridhar to present the memento to the speakers. Sir?
Very good evening to one and all present here. Today, Abinov and I will be taking you all through the various appeal remedies that are provided in the income tax statute, the processes that are involved, and we'll also be helping you out in how to draft such appeals and present it before the concerned authorities. So before getting into the topic, how does an appeal arise? It arises because we are agreed to an order, and that order is the first order that we receive is the assessment order in the Income Tax Act. Now, initially everything was going in physical mode where if your case is picked up for scrutiny, your jurisdictional assessing officer will issue notice to you and you will go meet that person physically. He will ask you for some documents. Everything was happening in a physical interface manner. Now that was creating some trust issues, so because of which the National Faceless Assessment Scheme was brought in. Now with this scheme is very clear that nobody will know who is handling your case. That is, I will not know where my case is being handled, but he will know who the client is. My case can be handled by an assessment unit which is there in any state. So that is why they wanted to bring this. They wanted to bring in some transparency, so that is why this faceless scheme was brought in. Now this scheme was brought in the year 2019 and it was embedded into the statute from 1/4/2021 and section 144B. Now the main component of this scheme is that there will be no physical interface between the assessee and the assessing authorities. Now the question may arise whether every proceeding is under faceless or not. The answer is no. There are some inclusions and there are some exclusions. Inclusions are that the original assessment proceedings will be under the faceless manner, starting from issuing a 143(2) notice until a final assessment order is passed. Then a 144B, best judgment assessment. So it is a scenario where your case will be taken up for scrutiny. Show cause notices will be issued to you, but you may not have replied to it. If that is the case, then the assessing officer, with whatever material that he has in his hand, to the best of his knowledge, will pass an assessment. So that is called as best judgment assessment. This is part of faceless. The third is the reassessment proceedings that are enunciated in section 147, 148. So from this also from scratch to it, everything is done through faceless. And certain penalty proceedings like non-compliance of notice, direction or order passed, and non-compliance of notice in any direction if you don't follow all that, those penalty proceedings will also be subject to faceless. So what are excluded? Search proceedings are excluded. Why? Because search proceedings are generally very complex in nature. That has to be done with utmost care and caution. So therefore, if you do it in a faceless manner, it may not work out that efficiently. So therefore, they have excluded such proceedings from faceless assessment scheme. The second is any assessment that relates to international charges, for example, transfer pricing issues. That is also very complex in nature, which cannot be done effectively in a faceless, so that is being excluded. And certain penalties that are not included, they are also excluded from the faceless assessment scheme. Now, like I said, for you to file an appeal, you should receive an order that you are imputed against. So that is the assessment order. So before we get into this concept of appeal, let us first understand the modalities of assessment. Now what happens in an assessment procedure? So you file your return of income, you admit saying this is the total income that should be assessed in my case. Then the scenario could be that they can accept your return of income and no proceedings can take place. The other scenario is they have some issues with the return of income that you have filed, so therefore they want to pick your case for scrutiny. If that is the case, what happens? They issue a notice under 143(2). This 143, so there are some checklists that you need to do when you receive this notice. This 143(2) notice should ideally be issued within 3 months from the end of the year in which you have filed your return of income. If it is not issued, then that is a ground for challenge. The second thing that you need to see when you receive a 143(2) notice is whether it is a notice issued for taking your scrutiny for limited purpose or complete purpose. Limited purpose means they will say that we have gone through your return of income, we find that these and these issues are not elaborated, so therefore we require some documents from you. This is called limited scrutiny. Complete scrutiny is where they can take your case for any issue that they want. Now, suppose your case is selected for limited scrutiny. Then assessment proceedings takes place. Then they take up an issue that was not even there in the 143(2) notice, then that is a ground for challenge. Because to convert the limited scrutiny into complete scrutiny, there is a procedure that they have to follow. They have to take a prior approval from a principal commissioner of income tax. If that approval is not taken, then that is also another ground for challenge. Okay. The next thing is, once you receive a 143(2) notice, you will also be given a 142(1) questionnaire, where they will send you a list of questions as to what documents they require with respect to this particular issue. You have to reply to those notices. They can give you a number of 142(1) notices, and if at all within the timeline that they have prescribed you are not able to file your reply, you can seek for adjournment in the portal. The portal will ideally give you only 15 days time. At one instance, you can only ask for 15 days. You can ask any number of time you want, provided they give. But at one go, you can only ask for 15 days adjournment. Then after that, After submitting your replies, a draft assessment order will be passed in your case. Now this draft assessment order has to be scrutinized by you very seriously and clearly. So draft assessment order will be with a show cause notice. It will say as to that these are the issues that we don't agree with you with whatever submissions you've given. For these issues, we want to make these additions. Show cause as to why these additions should not be made in your case. This is what draft assessment order will tell you. Once you receive this order, you have to give a detailed reply. For every addition that they propose to make in your case, you have to give a detailed reply with all necessary evidence that you want to. If you want to cite some case laws, please do. Generally, it is advisable if you cite Supreme Court cases and your jurisdictional High Court cases because that are binding on the authorities. Now, once you do all that, you should also seek for an opportunity of personal hearing in your reply. And in the faceless, in the portal, you also have a separate tab where you can seek for personal hearing. That also you should give. Then, once you file your reply, they should give you an opportunity of personal hearing if that has been sought. They will give you one hearing. Generally, the hearing is such that you will not know who is taking your case. The screen will be blank. You will be talking to someone who is not even there. So, it is not generally very effective with whatever experiences we have. We have been talking to a blank screen and questions will be posed. Sometimes they are very irrelevant to the situations. So, according to our personal experiences, this personal hearing was not that effective. Then once that is given, a final assessment order will be passed in your case. This final assessment order should ideally include all submissions that you have made. It should also include whatever submissions you made during personal hearing, and the final assessment order should be passed. Once the final assessment order is passed, again scrutinize, see what all facts have been missed in the final assessment order, see whether all your replies are considered properly. See, you will file a lot of replies. When you receive 142 notice, you will be replying a lot of letters to them. So see whether all the letters are considered when they pass the order. There could be scenarios where they could have left one reply that you have filed and that could be crucial to the case. So make sure to see whether all the replies that you have given are considered in the order. Then you should see whether the order is a speaking order and it should be a well-reasoned order. They cannot simply say in one line that these evidences that you are given is not correct, we don't agree to it, therefore we propose to make this addition. That is not right. Then if you are citing any case laws on a proposition of law and if they do not agree with it, they have to pass a recent order saying why they don't agree with that proposition that you have made. They cannot simply say that, no, this judgment is not applicable to your facts. If there is a simple line like that, then that is a ground for challenge. So therefore, once you receive this assessment order, before going into an appeal, the first appellate authority is the CIT appeal, sir. Before you get into it, kindly read the final assessment order, note down the points on which you can challenge. Yes, if there are some jurisdictional issues, you can file it. If not, if you want to go through the appeal remedy, take every point that you can take as a ground when you file an appeal before CIT, and then file your CIT appeal. So now the appeal remedy that lies before the CIT and ICAI, I hand over the mic to Abinov. He will take over.
Thank you, Janane. Good evening to all present here, and thank you for the opportunity. So, in the next few slides, I'll be talking specifically about how you should be going about when you prefer an appeal before the Commissioner appeals and then a consequent appeal with the ICAI. Now, as far as the Income Tax Act is concerned, the hierarchy of appeals flows as follows. So, as Janane was explaining, to start with an assessment order, or it can be other orders also which are appealable under 246A, which will be dealing in subsequent slides. But to just give an overview, start with the assessing officer, and from the assessing officer, you prefer an appeal before Commissioner of Income Tax Appeals. Now, as she was saying, the faceless scheme is not only applicable to the assessment stage, that also applies to the appeal stage as well. There is something called as a National Faceless Appeal Center, and all of this, the appeals are also faceless. The exclusions again are with regards to central charges where the search proceedings take place, or the international charges for that matter. Then, so what happens? Once an order you receive, you have to appeal against that order within 30 days from the date of receiving that particular order before the Commissioner appeals. Once the Commissioner appeals or the NFAC passes an order, you can prefer an appeal against that particular order before the income tax appellate tribunal. And the time limit for that is 2 months. Now, to just, I will deal with this in detail, but just to give an overview, before 1/10/2024, the Act read as 60 days from the receipt of order. Now that has been amended to 2 months. Again, this particular amendment is more to give a leeway to the department to be able to file appeals whenever they want to against the CIT order. And another thing, against an assessment order, the right to prefer an appeal only lies with the assessees. The department do not have a right to appeal against an assessment order because they are the ones who have caused it. They have other powers, such as the commissioner has the power to revise the order under 263 or rectify an order under 154 by taking the suo motu cognizance. Now, from the ITAT, we can appeal before the High Court, and the time limit for that will be 120 days. And from the High Court, you have an appeal remedy before the Supreme Court. Again, before the Supreme Court, when an appeal lies, it's not like the other appeals where we ourselves go and prefer an appeal. The High Court themselves will have to first say that it is a fit case for you to appeal to the Supreme Court. And all this will be dealing in detail through the procedure. Now, one more thing is, as regards to appeal by the department, there is a monetary limit. As far as the assessees are concerned, doesn't matter what the amount in dispute is. The assessees have a right to go on appeal till the High Court or the Supreme Court, irrespective of about whatever the amount is. Whereas when it comes to the department, there are specific monetary limits. Say for example, if the department has to appeal against an order of the commissioner appeal before the tribunal, there is a monetary limit of 60 lakhs. So if the demand is below 60 lakhs, the department cannot appeal against that order before the tribunal. So goes for the High Court and the Supreme Court. The monetary limits are 2 crores as far as High Court is concerned and 5 crores as far as Supreme Court is concerned. These thresholds were less, but through the circular recently by number 9 of 2024, they have increased the monetary limits for the specific reason that they bring down the amount of litigation that's already going on before various appellate forums. But there are gaps there. As far as the monetary limits are concerned, it's not like the department is totally ousted from going on appeal. There are certain exclusions that are provided as far as the monetary limits are concerned. So, for example, there's any provision or rule or notification which has been held unconstitutional. They can still go, the department can still appeal against an order of the CIT, ITAT or the High Court, irrespective of the monetary limits. Say that another instance can be where an order notification instruction has been held ultra-virus or illegal. So goes for, say for example, if an proceeding or an assessment is based on, say, information received from any search or investigation which is already going on, those are also exclusions. Now, what are the various appealable orders as far as the Commissioner of Income Tax appeal is concerned? One, so we file a return of income, return gets processed by CPC, we receive an intimation. Now, through that information, 2 things can happen. Either they accept our return and whatever is there, just go ahead, no problem ahead. Or they may not, the CPC while processing the intimation might not accept whatever I returned and may cause and may put out few variations. This intimation that we receive under 143(1) can also be appealed against before the Commissioner of Income Tax appeals on the NFAC under section 246. And appeal against a 143 order is there, and then as she was discussing a best judgment assessment under 144 where they keep asking for information, I don't give them information, and they go ahead and pass an order with whatever they have, that's also an appealable order. And then you receive, if there's an assessment that is completed as per 147 where reassessment proceedings were initiated, you have an order against you, you can prefer an appeal against that as well. And in cases of search or inquisition under 153A, a rectification order under 154 is also an appealable order before the Commission of Appeals. And if there's an order taking as to be an agent of NRA under 163, that's an appealable order. Any assessment order after HUF partition is one. Order of grant of refund or orders made under 201 with regards to where a person is called an assigned default for not electing TDS. Again, one small thing here is one thing that needs to be checked when it comes to orders under 201, the orders are issued under your time. Therefore, whereas where other proceedings are concerned, we appeal against that in the PAN portal. Where as far as TDS proceedings are concerned, it's issued under TAN. Therefore, you have to log into your TAN credentials to even be able to see what the orders are so that you can appeal against them. And orders made under 260 with regards to TCS, those are also appealable orders under 246. Now, before getting into the aspect of what all you need to do as far as filing Form 35 is concerned, we thought we'll discuss something of the concept of doctrine of merger. Why is it even relevant? Is because you need to exactly know against which order you are preferring an appeal against. Now, let's take a case study. Say you have you filed a return income, your return income has been processed, and then you receive an intimation. Now, the intimation passed. They say there are variances with regards to two issues. Could be any deduction or exemption that is made, for example. And against this particular intimation, I have a remedy of rectifying that under 154 if I find a mistake apparent on record. Let's assume that I filed that rectification under 154 also, but I have not appealed against the intimation under 143.1, which is an appealable order. Then my assessment gets picked up for scrutiny, and once the scrutiny is over, an assessment order is passed comprising the same issues without any discussion. Say, for example, my 143.1 said, the intimation said that 2 lakh rupees is a variance. Because, say, take the example of 43B, where you ought to have paid something to claim this reduction, you have not paid, variance is shown, 2 lakh rupees is the variation. Assessment order is picked up, or scrutiny is picked up, assessment order is passed, merely says that there is a variance, you have not paid the 43B, what? No discussion, nothing. Now the question arises, now you have an intimation, which gives you a variation. You also have an assessment order, which gives you that variation. Both these are appealable orders before the commission of fees. Question that comes is, will this 143.1 intimation automatically merge with the 143.3 order, and therefore, is it sufficient if you only file an appeal against the 143.3 order? That's the question. So there is this Bangalore ICAI decision which focuses on this particular fact pattern. What they say is, 143.1 variance is there. 143.1 is an appealable order before the Commissioner of Appeals. Your assessment order talks only about that variance, does not discuss anything. The ratio that they lay down in this case is a 143.1 intimation does not automatically merge with your assessment order. Therefore, in such cases, it is the 143.1 intimation against which you should ideally go on appeal and not the assessment order. But in this case, the peculiar fact is, though I did not go on appeal against the 143.1 intimation, I had sought for a remedy of rectification which was pending disposal. They said, let them dispose 154. It's not like I sat without doing anything against the 143.1 order. They said, let them dispose 154, whether it is in favor or not. You please delay, you please condone the delay, which is there, ask the ICAI to file an appeal against the 143.1 intimation. So the takeaway from this case is, 143.1 intimation does not automatically merge with the 143.3 order just because issues are there. Now, we go to the next case study and slightly tweak the facts. See again, same two variations. SC has not appealed against intimation. Assessment proceedings have been, scrutiny was picked up, assessment order passed, but it has been passed for two different issues. Exactly. Yes? Now what happens? Will your 143.1 merge with 143.3 and is it sufficient? If you only appeal against 143.3, the answer to the question is no. Yes. So as far as the assessment order is concerned, it deals with separate issues. Your variance is separate under whatever the intimation is. Therefore, you have to appeal against both of them. If you miss the bus for 143.1, not appealing it, your assessment order, if you see when they compute your assessed income, they will just mention variance as per 143.1, so and so. So if you miss the bus there, it means that has obtained finality, you have not challenged it, and therefore you will miss the bus. Therefore, if issues are different, and 143 intimation is there, and what is there in the assessment order, you must ensure that you appeal against both of them. If you miss the bus in 143.1, it becomes very difficult for you to do. Because it's an appellate proceedings, nobody is going to stop us from taking grounds before the CID is saying that this variance was there and appeal, but very difficult to get over that. Now the next case study is 143.1 has been passed. There are two variances. before going to an appeal, if I feel that there is some mistake apparent on record as far as that intimation is concerned, the Income Tax Act gives me an opportunity to rectify that mistake by making an application under 154. Now, 154, say for example, I filed my 154, 154 is rejected. Now, I have invited two orders. One, I have an intimation against me. I filed an application under 154, that is also rejected. The question that now arises is, is it sufficient if I just appeal against 147 intimation, or is it sufficient if I just appeal against 154, or should I appeal against both of them? So, the answer is you appeal against both of them because both of them relate to different issues. Your 143 one variance will be on right. Your 153, 154 application, when they dispose it, they will merely say that there is no mistake apparent on record and dismiss it. If you are aggrieved by that, by saying that the finding of the assessing officer that there is no mistake apparent on record, challenge the 143 one again in appeal on it, and if you want to challenge the 154, if it is not given properly, this again that. That's what both of them have to be challenged. This is a case where 143.1 again with two variances. I filed an appeal against that intimation. When scrutiny was picked up, whatever issues were there in my 143 intimation were properly discussed in my assessment order. Assessment order is passed. So what happens? Before an assessment order is passed, you have already gone on appeal against the 143 intimation. Now, against the 143 order, you are supposed to go on appeal. The question that arises is, what will happen to my appeal, which I filed against the 143 intimation? The answer to the question is, in this case also, similar fact. What happened is, now that those two issues, which were part of the intimation, are specifically discussed with proper reasoning in your assessment order, your 143 one will merge with 143.3, and therefore the appeal that you filed against the 143 intimation will be infructuous, and you have to carry the assessment order of appeal before the income tax appeal of CIT or NFA. The next one is, now all along we have been talking about the merger between an intimation under 143.1 and an assessment order under 143.3. Now there is a chance where your assessment is completed. They have said, oh, these are the issues, and it's completed. The department has powers under 147 to initiate reassessment proceedings. Say they have some information which suggests that income charge would have escaped assessment. So for these issues, we initiate assessment. Now when an assessment order was passed, say for example it was passed on two issues. Say we can be a 14 or a 37. When they picked up your when they initiated reassessment proceedings, there were 5 issues, for example, when they passed the reassessment order. 2 issues which are already dealt in the assessment order, and 3 new issues. Now, what happens? Will your 143.3 automatically merge with 147 or not? The answer to the question is, doctrine of merger will apply, because 2 issues which are there in the assessment order has also been discussed here. Therefore, the order that you want to appeal is this one, and whatever appeal was there before, not surveyed. Maybe also. The last case study that we thought we'll take is, so all along, we have been talking about the concept of doctrine of merger, and the basic underlying principle is doctrine of merger will apply in a scenario where there is an order of lower authority and which has been appealed against before a higher authority. Doctrine of merger is where the lower authority's order merges with the higher authority. Now what happens in cases where there is a 143.3 order for which I have gone on a rectification under 154? Will doctrine of merger also apply to cases between 143.3 and 154? Now the law behind that is that doctrine of merger, as I was just saying, will only apply to a scenario where there is an order, where there are 2 orders relating to one being a lower authority and the other being a higher authority. When you take 143.3 versus 154, both are the assessing officer. Therefore, doctrine of merger will not apply to a case where the same officer is either rectifying or reviewing his own order. If you get into this case study, say for example, an assessment order is passed with an addition of 1 lakh rupees. Then I filed a rectification application under 154. There can be three possibilities. One, they accept that yes, there is mistake apparent on record, we will rectify, pass an effect order, get that with it. Second would be, they say no, whatever addition has been made is not mistake apparent on record, they will go ahead and accept it. Third, say for example, so 154 is not a remedy only available to the SCs. When the SC officer sumoto can initiate 154. Say the third case where the addition was only 1 lakh, but they found no, there is a mistake, something there, it has to be 2 lakhs. So in this scenario, there are two scenarios against which you have to prefer an appeal. To take the first one, where rectification application rejected, stating that there is no mistake apparent on record. This we discussed earlier itself. You appeal against the order, you will appeal against 154 if you are aggrieved by the fact that they have not read how this is not mistake apparent on record. Next question comes up where an enhancement happens. 1 lakh was the addition. He has enhanced it to 2 lakhs. What happens? In that scenario, against the 1 lakh addition, you will appeal against that order before the commissioner. And against the enhancement, you have to also appeal against the order. Clear till now? Any doubts? So, to just summarize.
Sir.
Yes, sir.
Both order proceeded to appeal commission.
Yes, sir.
154 is passed order. What about the other order?
Sir, if I
143,
yes, sir. If I understand your question correctly, you are
154 accepted. What about the other order?
sir. So the example is 143 passed.
This is 2 possibilities.
Correct.
154. Another one is appeal commission.
Correct.
The 154 is accepted.
If 143, so going by your question, in 143 is 1 lakh of addition. I applied for rectification against this order, saying there is a mistake apparent on record. This 1 lakh I am not even this addition should have not been made. If your 154 application is accepted, saying yes, there is mistake apparent on record, no problem. That's
Case is
all.
over.
Yes, that's the first thing.
The appeal is not
required. Yes. That's the first scenario. If they accept that there is mistake apparent on record, then the addition that was made to the order is nullified, and they will pass an effect order to this effect. Therefore, no appeal.
Both issues.
Yes. Then the complication arises when they don't accept, then you have to challenge both. Or if they enhance, you have to challenge for the initial portion against this order and the enhancement before 154 and try both of them. So yes. So with this, the whole point behind trying to appraise you with the doctrine of Fazil is to only ensure that we don't miss the opportunity of appealing against various orders. And when will doctrine of Fazil apply, to be very sure that you don't miss out on appealing against the orders that are supposed to be.
Yes. So I will be going for appeal for the 1 lakh of enhancement each 154 and 143.
Yes.
It will be a normal thing. You have to appeal
Against the
143.
Just because my rectification is rejected, so I go on appeal for both 143 and 154.
Yes. Because rectification is rejected on the point that they are saying there is no mistake apparent on record. What is the reason? You have to see the order. If it's justifiable, then you find out the original addition against the order. If not justifiable, then you go on 154. What happens? Yes. Now we'll come back to how you file an appeal when it comes to Commission of Income Tax Appeals or anything. So, as far as how it should be filed, Rule 45 will tell you how you should file, and the relevant form for filing an appeal before the Commission of Appeals is Form 35. Now, this has to be filed electronically in your income tax appeal or in your income tax portal, and verification must be done by person authorized to verify your ROI. And if appeal relates to order number 201, as I was earlier saying, those will feature in your tag login on the income tax portal. Therefore, there you have to file an appeal. Manner again, the appeal shall be made before the CAT or before. Now, the next question is, when you file an appeal in your form, there is some appeal fee that you have to pay for it. And how do you determine that? If the total income computed by zero is less than 1 lakh, it's 250 rupees. If it's 1 lakh to 2 lakhs, above that is and subject matter not covered under this or penalty issues and all that, that the appeal is 250 rupees. That even when you initially it was in a different portal, now they have brought it into the income tax portal itself for you to be able to pay it and then you get a challan. You have to enroll the file. Now, what is the limitation? Again, as I was saying, you have 30 days from the date of receipt of that order, from the file appeal against that order. And how should you see this 30 days? If an appeal with respect to denial of TDS, then from the date on which the payment of tax was made. If the appeal is with regards to assessment or penalty, then the date of service of the notice of demand under 156. Now, the interesting question is, I missed that 30 days. What happens? Right. Condonation has to be applied. Now, the next question is, do the officers or do the Joint Commission of Tax Appeals or CAT have unlimited powers? When it comes to indirect tax, it's specific. You have a specific timeline within which they can go and give you that extra 1 month. Whereas Income Tax Act is concerned, the discretionary power is unlimited. So it's not like in GST where you have 3 months and then you have maximum you do it for 2 months. Post that you go to the High Court and try and get it as far as official power is concerned. But income tax, the officers or they have unlimited powers to control delay. We'll come to that. And the delay, you must be able to give a sufficient cause as to why you miss the bus and you will file the. Now, the crucial fact is if you miss that 30 days, you have to file a continuation of a delay application. Now, this application must be made if there is a delay, yes, and the application must be accompanied with an affidavit giving what are the reasons for delay for them to even consider and control that particular delay. We come to that, what are the sufficient causes. And when I file that application, the CID must determine whether what I am saying is or what I am presenting is a sufficient cause or not. And say for example, you file a condonation of delay application, they reject it, what happens? Against that, the remedy is that you go on appeal against that rejection before the tribunal. For the limited point of this rejection, argue before the tribunal and say why you have a sufficient cause for which your delay can be controlled. If the tribunal is satisfied, they will control your delay and send it back to the CID to adjudicate the matter on merits. Now,
what if affidavit is not gone along with the condonation? Still it can be rejected or still it can be approved?
no, if you can get it.
You said that condonation of application should be applied, condonation for delay should be applied along with affidavit.
Correct.
Stating the reasons for condonation.
Correct.
If affidavit is not gone,
That's a prerequisite.
but if affidavit is not gone, we have only given the condonation application.
Now, what do you mean by it has not gone?
No, I'm not saying particular.
The reason. No, only the reason if you have given reason of the
Reason somebody should attest that this is the reason why
That's
I was
the
not
major
able to
reason
file
behind
it.
you having.
That is why it is called as an affidavit. So you have to attest that I was not able to file it. This is the reason. So this has to be attested by someone. Otherwise, your application will not be admitted unless it is accompanied.
It's not like the application can make for everything. Here, because I've done not beyond something, I'm trying to tell them that so these affidavits will be filed by the authorized person of any if it's a company or if it's an individual, they do it by themselves. So just be sure that if something wrong is being stated, who will tell you?
Is it individual?
It's themselves. Now again, what is sufficient cause? Again, something that is beyond your control that you couldn't do, and therefore you are seeking for this. So you just kind of tried and again, this exercise for power of condonation from delay is discretionary. Maybe to 1 SC they would have given some 300, 400 days delay, they would have given. That does not mean for every SC they have given. It's a discretionary power.
Let me just add one thing. In fact, the reasons that you cite in your condonation affidavit, you will say medical reason, you will say I had to change office, I lost my files, so I couldn't file. So in fact, there is a recent High Court order where the judge has said that no condonation affidavit should contain these reasons. And the common reasons that we cite generally for condoning the delay
all those has been mentioned in the judgment saying these should not be cited as reasons for when you file a condemnation affidavit. Now we have to think of new reasons when we file a condemnation affidavit.
Usually, associated coming with ignorance of law.
Right.
We don't give the reason to condemnation.
Yeah.
What's the other reason? What's the other reason?
I think we have to find out more. Now because the judgment has come out saying don't cite these reasons. If you cite these reasons, we will not entertain your application.
But if it is merely because the assessee has actually not received the notice and it was related to some other mail ID or something, we just
We will come to that.
So, like, few common ones are, say for example, an order is passed against you. That order is available before the commission of appeals. But here, for example, if it's a 148 or 143, you have some issue on jurisdiction or you try other alternatives for going to the appeal, that time taken in trying other remedies may be a valid cause. That's one. And second, say, this particular case of sodium mining, what would happen is, as the order would be passed, they would wait for the expenditure which would have not been allowed. They were not appealed against it. Post which, for that particular issue, the High Court would have said that this is an allowable issue. 30 days have crossed, so I did appeal saying yes, okay, it is against me anyways. And then, High Court of Supreme Court order changes the legal position. Post that I can go on appeal, cite this as the reason, and get my delay control.
Will say, in that case, because the judgment has come post, my case was determined prior to that. This case will say.
But if there's a change in the legal position, then that will not be a problem. Because that's something that you're eligible for. Because it's not like before, or it's not like when you fight the income, they claim it as an eligible. But they decided against me for completion. But if the legal position changes, then as per this case of people could have and as we are asking, non-service of assessment order to be registered in ICAI. Say for example, service of notice is mandatory. Mere uploading the orders in the ICs have to keep a check of the portal to see when the order is uploaded, and then that's a separate question of whether that's a valid service or not. But there are cases by the Honorable Madras High Court themselves which say that mere uploading of orders will not mean that you have served the order. If there is a registered email ID, you ought to have served. So, though it's uploaded in the portal, if I miss it, maybe these reasons can also be cited for you to get it controlled. And there are a few cases on the aspect of non-availability of legal counsel or say on the advice of tax consultant for not appeal. Those have also been considered as, but again, these are decisions prior to the High Court decision. So going forward maybe, but yes, if there is a genuine sufficient cause because of which you have not been able to do so maybe you can try and run and get it controlled. But the rule is we try and file it by the means.
Would you be releasing registered mail ID? So what's the registered mail ID on the last file return? Will that be considered as a registered mail ID or the primary mail ID of the income tax portal?
Most probably both have to be same. Okay. What you give in a income tax return will be one.
Supposedly it is not same.
Supposedly it is not same, then maybe you can take an argument that I filed a return, but then I got it changed in my income tax portal. Then whatever is the latest one, because you have access to both of them. Keep the return.
So finally, is a case of where the return, previous file return, the assessee's primary mail ID was correct. But when he got the assessment, the primary mail ID was changed to the consultant's mail ID.
Did we intimate it to the department?
Yes, we did.
Then it's, if an intimation with regards to the change of email ID has been specifically given to the department.
Still it's been addressed to the same mail ID.
You are saying still the old one?
Still the old primary mail.
There are cases which say that you give an intimation to them. Yes. Because I changed it, please issue and notice to me on this. They are very good on this.
They are not done
it. Things happen there. Before they do. Yeah, that's.
Yes. Registered email ID has a definition also. Basic. That will also include whatever email ID you have updated in the last table. That you have updated your email ID in the portal, or you have given a written email ID in the last editor, then you can take the further.
Now we come to the aspect of how you file an appeal again. This Form 35 we are able to use in your and get into that. This I think most of us, I mean, if already deal with this, we are able to do that. So once you get into that thing, you will have these details which you will basic information will be for that, and then order against which appeal is filed, most probably that's not operated, it is already there. And pending appeals, whatever is there, to fulfill all of them. And appeal details, here I think you have to mention the fees that you have paid and that and all that. And details of taxes paid, again, whatever is there in your acknowledgement for the reason that you have failed to fulfill this. And then comes the crucial fact portion of statement of facts, grounds of appeal, and additional reports. So when it comes to filing an appeal before the CITA, the first thing that we have to keep in mind is list out each and every fact that is relevant. Say if it's an asset fraud against which you are making appeal, you start right from when you file your return. When did you file it? What did you what was the income that you offered for that? Then when was your 143 given? When was 142.1 given? What were the questions? What all did I answer? If you ensure that you don't miss out on any fact which is crucial to your case. Then comes to then once your and as far as the portal is concerned, it not accept those special characters. You ensure that special character is not there, but you will be able to go to the next step. And then comes the grounds of appeal. Now ground, when you take it, usually it's advisable that you start from the ground of jurisdiction. Now what all will come in this jurisdiction aspect? Say you specifically sought for a hearing, a personal hearing. They didn't give that due. At that threshold itself, resentment. Say for example, they asked you various subdivisions. You gave all of them. But those have not been discussed. Merely as introduced whatever is the in just past order, that is also not of challenge. Say I gave all my submissions. He has partly taken some, partly not taken some. That is also valid from the challenge. If all of this is not considered, then the first ground you will take is that the order is a non-speaking order. He has not applied his policy, so therefore it's liable to be quoted. And if the orders are with regards to reassessment and all that, then you get into the aspect of whether this has been given the passed by specified authority or not, whether the time limits have been taken. Therefore, when you start with the ground for appeal, it's advisable that you start with jurisdiction before getting into the merits. If you have a good strong jurisdiction, then there is no need to get into the merits. And once all of this on jurisdiction is done, then you get into the merits. If it's 37 disallowance or the current matter, then you get into specific, and the grounds that you take must be specific to that particular issue. And in the grounds of appeal, you must ensure that we don't bring in any fact or so, because it's just the grounds of appeal. So when you file the appeal, it's sufficient that you give the statement of facts and then the grounds of appeal. And once the appeal is filed, and when you get a 250 notice for hearing, that's when you should be ready with detailed submissions on each and every ground. Now, then comes, and as far as the attachments are concerned, you'll be asked to attach the social order, the demand, and it's advisable that you attach the challan that you have that gets generated for the appeal fee that is paid. And yes, so as far as, and this is as far as filing an appeal. Now, in 30 days, I filed an appeal. But as far as the 156 notice is concerned, the notice of demand, actually say, this is your demand. If you don't pay this within 30 days, we will initiate a recovery. I have gone on appeal. Whether we are going on appeal will stop the department from initiating the recovery proceedings. The question is answered no. You have to file a stay application before the jurisdiction licensing officer seeking for the stay of demand. So as far as seeking for a stay of demand is concerned, there is an instruction which is there, which says that if 20% of the demand is deposited, we give you a stay. But again, this particular instruction is not mandated. There can be cases or when if there is a particular issue for which you feel that this demand declaration should have ideally not been made, a stay application for seeking full stay of demand can be sought for. The instruction which gives that 20% is 20% of demand, that also gives you exclusions on both the counts. I seek for full stay of demand, or I can tell the department, I am ready to pay 20%, you stay the recovery until my appeal is disposed. If it's a scenario where in my previous years, for this particular issue, if it's against me, the ICAI officer is well within his range to go beyond 20% also. Whereas if it's the reverse, that in the previous years those issues are covered in my favor, in those cases also, they can give you a lump sum which is below the 20% threshold. And the important thing is, file the appeal within 30 days and also file the stay application, because from 31st day, as per the 156 notice, the department has the right to issue recovery proceeding. Though they don't do it so stringently, but to be on the safer side, it's advisable to do so. Now, each stay application, what are the essential aspects that you have to cover? So there is something called as the Trinity principle, which the court has mentioned to say what are the three essential aspects that you must ensure when you file a stay application. First, what is your prima facie case, and how you'll be able to get over that and say that this addition ideally should not be there. What's the prima facie case? Second, it's extremely important to come out and elaborate as to that you have a financial difficulty or stringency, and if you are made to pay this 20% or more or less, it will amount to undue hardship and relate to the loss and balance of convenience as well. That is, it's anyways not paid. Wait for it. If it's set against me, then you go forward. And in your application, very briefly, also merits you may need to mention, because when he passes an order, he has to consider everything in passing order. And when you file a stay application, enclose Form 35. The reason for that, I just not do. So I file a stay application. What happens? The AO has to dispose it within 2 weeks. Now, either I ask for full stay, he gives me full stay, I go on appeal, wait for it. Or the second thing can be, no, he says you pay some amount. Now, if I am aggrieved by that order, I can review that order, file a review against that order before the Principal Commissioner or the CID, and that review will be disposed in 2 weeks. Now, what if that is also decided against you? You go on writ before the Honorable High Court, challenging this order, saying I should ideally not be paying, but more often than not, the High Courts tend to lean towards payment of 20%. Again, when there are instances where the High Court has interfered and said the order that you have passed cannot be acceptable, and these are few Madras High Court decisions that we can't really come up with. The order that he passes or the rejection that he gives, if at all one, against your application, that must be a speaking order. He cannot merely say, instruction is there, it says you have to pay 20%, please pay 20%. If you receive an order like that against your stay application, you can go against that before the High Court, get it bought, and then he has to give a reason for it. There is even a case where my application was bereft of details, I didn't give him everything. He said, do not give him everything, pay 20%. High Court has gone one step ahead to say, you cannot give a blanket direction of 20%. He has given you a memorandum of appeal. From that, you will be able to know what are the issues and what all has happened. You have to consider that and only pass an order. Therefore, a stay application, merely a given application, and he cannot reject it saying, instruction says 20%, you pay that 20%. It's not mandatory. So, when you receive that order rejecting your stay application, I have to see various grounds whether he has seen all my statements, is he able to disprove that I don't have financial difficulties also. So that's as regards the filing of the applications. The next crucial aspect is production of additional evidence. Before the ICAI officer for a particular issue, we were given few evidences, order will be passed. Now before the I missed something. Now under the Income Tax Act, under its rules, under Rule
what did he say? I can produce additional evidences subject to these four exceptions. One is where the AO has refused to admit any evidence which he wanted to admit, or where the applicant was prevented by a sufficient cause from producing the evidence which was called for by the AO. Third scenario is he didn't call for it, but I had sufficient cause to not admit it. And third, AO has passed an order without giving sufficient opportunity to even give that evidence. Say, for example, you have only 2 days to give sufficient and produce evidences, and in those 2 days you could do only so much. You have also stated in an order that you gave unit to a limited time to do so. I am giving all of this. You please give me one more opportunity. Left of this, you go and pass an order. You appeal against that order, and that end you can produce the additional evidences before the commissioner appeals with this. Again, the 3 things are not admitted. If he doesn't admit your evidence, that's reason for you to produce one. Or he did not give you the additional opportunity to do so, that's one. And again, the commissioner of appeals himself has the powers to ask you to produce additional evidence. If they feel for a matter that please produce this, that's also. Now these are certain practical scenarios where the courts have come ahead and said when you need to when additional evidence can be given. So one such case is this FIR or the AG, in the case of Delhi Diamond Jubilee, where the SC it is a trafficking case where reasonable opportunity was not given, and then order was passed. Before the tribunal, I said that additional evidence that to submit, detailing all this shotguns and all that. And if the court, if the CID feels that additional evidence will go to the root cause of that particular case, they will go ahead and admit it and you can submit that particular thing. And when they admit the additional evidence, when they say that yes, you can go ahead and do, from their part also, they have to give proper reasons in writing because the AO will have a chance. And as if they are rejecting the application, they also have to give you specific reasons why they feel that this additional evidence is not necessary. Again, what is the procedure? Just a brief overview. If the IC is going to represent himself, then fine. If you want someone that is to represent, then as and when you file the appeal, you get a wakalat memo for the advocate or power of attorney from the CA and get it paid. And that has to be affixed to the court fee of stamp regular applicable. And then, as I was saying, once you file an appeal, it's imperative to also file a stay application. And then, as we were discussing, once the stay application, whatever happens to that, then you take that recourse and see if something can be worked out. Let's say it's 20% or more or less. If you have the remedy against whether it's more or review, try and enforce that as well. And then the order, again, when it comes to the commissioner of appeals, generally the timeline is 1 year. Again, that depends on how the case goes and all that. Powers of the CID, yes, it's right, it's both organizations that as an officer. They can restrict they can examine other issues which are not even in the particular organizing file. They have wide powers. And they can confirm, enhance, reduce, or even and yes. So the powers as far as the CID are concerned under 246A are right. So with this, we can say any questions on this. Now, once an order of the CPE is out, the next course of remedy, appeal remedy you have before the income tax tribunal. Now, the relevant form that is applicable as far as appealing to the income tax is concerned is form 36. Now, we just tried and extracted tokens. So, one thing that you have to keep in mind is all the details have been filled in. But one thing that you have to keep in mind is the respondent when we fill, it has to be the jurisdiction as a It's not the NFAC or the National Field Assessment Center. It's the jurisdiction as the officer who has to be mentioned when it comes to the respondent. And again, you go ahead and fill the respective amount regards to what was the assessment, what is the addition, all that. And with regards to the amount, you can either take it to the assessment project or if there's an effect order to that, then that may be taken into account. Then comes the grounds for appeal. Now, when it comes to the grounds of appeal, a separate sheet or part of, like if we take in
it has that specifically states. Now, one thing, even before the CAT, even before the CATA or even before the ICAI, one thing that we have to specifically mention, every time you take the last from state, that you may be allowed to add, modify or delete. It's crucial because that clause is not there and then that becomes the answer again. So, read before the tribunal, read before CATA, take a specific note that you may be permitted to add, modify or delete any clause for that matter. And again, so if it's an appeal by the tribunal, more often than not, they may not go on appeal if it's a tax effect case. But for our own thing, we may also check if it's a department appeal for the ICAI against the CAT's order. First thing we'll check is whether this is within the monetary limit or not. If it's below and if they file an appeal, no answer of going made out of that. Just say that this is beyond the threshold, and at that stage itself, the tribunal will get done with that case. And again, if now it's 2 months. If the time limit for filing an appeal to the tribunal is 2 months from the date of receipt of the order, if you miss the bus, again, have to go through the angle of filing a continuation application, giving sufficient cost and all of that. And even the ICAI has unlimited powers to control the lien. And appeal fees. I would imagine that. Now, what are the appealable orders? Before the tribunal, you have 154, 250, which is the Commissioner of Appeal order, and order passed by GCIT under 154. So these are the various orders that are appealable before the income tax appeal tribunal. Again, this is what I was saying. Under 253, subsection 3, it will give you the time limit before which you have to file an appeal. Prior to 1/10/2024, it writes as 60 days. From 1/10/2024, it reads as 2 months. Again, this is to give a leeway to the department because orders are being uploaded online on various specific dates, and with the amount of cases that's pending, it becomes difficult for the. That's what the memorandum to the Finance Bill says, that the reason behind changing this to 60 to per month or 2 months is to ensure that the department knows and this does not miss the orders which are being updated on daily basis. 2 months from the end of the month they should receive it. Again, as far as the fees portion is concerned, if it's less than 1 lakh rupees, then it's 500. If it's 1 lakh, 2 lakhs, then it's 1,500. If it's more than 2 lakhs, it's 10,000. And for those which are not covered, they can actually go. It's 500. And how will you pay this? It's there in income tax code. He filed that, he paid lakhs, and under the head new payment, you have to proceed against this particular specific rate of corporate tax and individual tax depending on whether it's company or individual. And then, as far as you have to enter that, again, the appeal fees when you pay, that has to be specific to the assessment year which is under dispute. He might be in this assessment year, but when you pay that challan, when you fill that challan and make the payment or when you enter details, it has to be for that specific assessment year. If you miss that, then again, new challan has to be sort of paid for the assessment year again. And then type of payment, there's the minor head will be other receipts and then it will be appeal fees. And when you go to that next page, you select the other option and enter whichever you fall under to pay the appeal fees. This is again what we were discussing as far as the grounds of appeal is concerned, and a brief summary of issues, what the CATA did. That's very important. And the way you take the ground of appeal is, say for a particular issue, you either say that the CATA is erred in holding, or he ought to have considered this but has not considered, or ought to have taken it into account. So when you draft those grounds of appeal, it's important that you use these phrases terminologies to ensure that, in a sense, you compile whatever the issues are which are agreed against when you file the grounds of appeal. Now, when it comes to the written submissions, it becomes very important to give detailed submissions for each and every issue. Right? So, when we say detailed, you have to give what are the background. Why is this addition even ideally not being made? What are the relevant facts? And it's important that you also, when you make the detailed written submissions, give legal precedent. Be it as far as ICAI is concerned, though they are constituted at different stages, they are ITAT actually does not have jurisdiction. So it's one ITAT, which for convenience purpose is constituted across. Therefore, if there are any, so if you have orders in favor of you for previous assessment years, very important. If you have any high court decisions in your own case, so when you collect cases, if there are cases in favor of you, that is first. If not, then other cases. Then it's as far as that is concerned, because the jurisdiction is slightly same, you can go ahead. But as a matter of practice, they prefer they prefer the jurisdiction high court's order. The Supreme Court, nothing like it. Again, this will again have, if the combination application, whatever was there, as far as the CATA was to give a sufficient cause as to why it's there, and as far as the application for the record is concerned, it has to be executed on a 100 rupee stamp paper, and reasons for delay has to be applied through an affidavit as it was in the previous case. And again, when the ITAT considers the COD, they have to tell in with proper reasoning and all that why they feel yes or no against the sufficient cause is there. And again, what are the powers of the ITAT? Very generic. It's whatever the powers are based on the court under CPE that's there. They can ask, they can make inquiries, investigations, etc. And any proceedings before the tribunal is deemed to be a judicial hearing. And this is also deemed to be a civil court as far as this is concerned. Orders passed by the ITAT, again, they have to, when it comes to the ITAT, actually there's no problem of whether you are given presentation opportunity or not, or they give you opportunity before they should do. And one thing again, so once, say for example, there may be 3 or 4 or even 1 or 2 hearings that you may have before the ITAT, depending upon the complexity of the case. So if it's a lengthy matter or if it's a difficult matter, which goes on for a lot of days, it's very important that you submit the summary of arguments that you have made during that day or so before the tribunal as and when you're done with that particular hearing. It goes on record. Therefore, when they pass an order, they have to consider all your submissions to pass an order. So, and before, say, there may be cases where they themselves will say, they heard you, we will pass orders. And if it's simple cases, then they themselves will not take more time, and it is, when it comes to complicated matters, very essential that you file your summary of the arguments that you made during the day. It also helps you when an order is passed to ensure whether the ITAT has taken into account all of that. Because sometimes if it's a difficult matter, it goes up for more than 2-3 hours or so, and then maybe they may note a few things, they may not note a few things. So from our end, it's very important that apart from the detailed written submissions that you file earlier, as and when the hearings are with the permission of the court, it's better that you file summary of arguments. And as you were saying initially, if there are decisions that have been relied by the Commissioner of Appeals or relied on some decision during the appeal which has not been properly considered, all those facts also have to be brought in. Because if something has not been considered properly, you're going to remand it back to the CATA and you're going to get another chance to present your case before them. So all that also becomes essential. And as far as rectification of mistake, if there is something mistake, if there is a mistake apart from record as far as the ITAT's order is concerned, there is a power to rectify its own order. Again, there has to be a mistake apart from record to do so. And again, this is just a flowchart that we need as to how we go about doing this form 3140. We can just maybe give this PPT as well for your reference. Next thing is with regards to cross application. I filed an appeal. Department has the right to file a cross application. The department's appeal. I have the right to do a cross application. Now again, as far as cross applications are concerned, it's dealt with in section 253, subsection 4 and subsection 5. The assessee or the assessing officer, on receipt of the notice that the appeal has been filed by either of the parties, within 30 days from that receipt, has to file a memorandum for cross applications. After 30 days, again, it's all into the convocation delay, getting into sufficient cause. And as far as this memorandum of cross application is concerned, the relevant form is Form 36C. 36 is for appeal before tribunal. 36A is for memorandum of cross objections. Similar to that of 36, would probably find the same. This is another thing. Now, in my written submissions, I will rely on various documents. I will rely on various positions. It's extremely imperative to file a paper. Through the practice, usually what we do is in the case that you have volume 1, volume 2. Volume 1, we usually keep all the necessary initial documents that you feel like if it relates to, say for example, an issue with regards to ATIAB, detention denied, with regards to an SEC. So all that which is relevant is, first of all, I should have, say for example, I'm a code developer and I have claimed the detention under ATIAB. Now that is being denied because I violate some conditions of the SEC Act. If that's the case, then all that becomes relevant is, first of all, my approval that I receive to be a code developer, my agreements. So when it comes to the first set of papers, you keep whatever you rely on as the page documents to further your case, and so on and so forth. And then there has to be a separate compilation for case laws. And for case laws, one thing that we have seen in the past is we put out 10-15 cases during the argument, which is going to say this paragraph is relevant, this paragraph is relevant. What approach we follow as an office when it comes to filing paper books or compilation of case laws is, we mention what the case cost item in the citation is. After the citation, we have a specific column to say what is the issue for which we are relying on this case. And then you will have another column which will specifically in the index provide for what is the relevant paragraph that you are citing. And in the index, we will also give two page references. One where the decision starts in the compilation, and the page number reference with regards to that particular paragraph that we are relying on. This is extremely helpful when it comes to the ITAT and the members when they see it. At times, what happens is we have also faced where for a matter we file about 6 or 5 compilations, where the judges specifically ask for a convenience set, where they say you give us a convenience set and you tell us what are the documents that you want to rely on. So this goes on depending on each member to member, but as far as the case law thing is concerned, as far as what we have been practicing, it's very important to say which case law, or what case we are citing, what is the relevant paragraph, what are the page numbers. This becomes easy when we argue also, to be on the, so, and again, index of documents. Again, with regards to production of additional evidences before the tribunal, again, as per Rule 29, parties shall not produce additional evidences, but the exclusions against are that something has not been admitted, or if it goes to the rule of the matter, the tribunal can agree to producing additional evidences. These are the circumstances that we thought we highlight. And in this Mahavir Prasad case, what happened? Some sale of share would have happened, and through that sale of shares, the SC would have gone and invested that in a residential property and claimed 50%. And the assessing officer would have denied that, saying it is not even long-term capital gains. So for me to prove that it's long-term capital gains, I will be able to prove that I get it for more than a certain period of 12 months. Before the assessing officer and the CATA, I was not able to give a particular letter which evidences the fact that I was holding this for more than 12 months. So before the tribunal, I made an application, the SC made an application which states that now I have this letter which will specifically evidence to the fact that I held it for more than a particular period for this to qualify as long-term capital gains. And the tribunal accepted the production of this because this goes to the root of the matter to be able to decide that matter efficiently. And again, so it's more of a discretion rather than the tribunal to either accept or not accept. And yes, the powers of the ITAT as far as to admit the additional evidences can be exercised when this evidence could have not been, as we saw for the commission of these. That's one. So another thing that comes is I filed all say I took a few grounds before the commission of these. Then I filed the form also, and I wish to take a particular ground. The question arises whether I can take a new ground from the title after the case. You can take a new ground before the ICAI, and a specific petition for that has to be filed, requesting for filing an additional ground. This has to be again signed by the SC and not the authorized administrator, which would be the advocate or the CA. And this might be the letter of a company if it's a company. And the same will be admitted if the tribunal accepts to do so. They are not bound by going ahead and saying, you took a ground that I may be permitted to add some ground, that will not be sufficient for the next. They must feel that adding this ground may be of relevance. For example, an order is passed beyond time limit. You forgot to see it. You appeal against that order. But you can raise a ground before the tribunal because it's a jurisdiction issue. And if the tribunal actually feels yes, say for example your assessment orders under 153 have to be passed within a specific timeline. If that has not been passed, you wish to take that ground, thinking I should ideally be taking grounds on merits and issue on jurisdiction. Then you later realize after filing the appeal that this order itself is time. Then again, those circumstances they will most probably admit it because the matter ends there with the order itself is time. So with this, I come to the end of the Commissioner Appeals and ICAI. If any doubts that you have with regards to these slides, I'll be happy to take them, or else I'll be passing it on to my and we will take you through the High Court and the Supreme Court.
Thanks, Abinov. So the next appellate remedy that lies with the SSA or the authorities after the order is passed by a tribunal is before the High Court. Now the relevant provision in the statute for filing this appeal is section 260A. So for every order that has been passed by ICAI and if you are agreed by it, you file an appeal before the High Court under 260A, provided it involves a substantial question of law. So what is substantial question of law? We will get to it later. So who can file this appeal? The Principal Chief Commissioner or a Chief Commissioner or a Commissioner or an assessee. Whoever is aggrieved by the order of ICAI can file this appeal. What is the timeline? Timeline is 120 days from the date on which you have received the order that you are in. Like other appellate remedies, here also there is no provision which says that there is a provision for condemnation. There is no time limit that is per se provided that this is within the time limit you can condone. So therefore High Court has inherent jurisdiction where they can condone the delay. Now practically what happens is, let us say you are filing an appeal with a condemnation application, you are an assessee. You are filing the appeal with a delay. Now when the matter comes up for admission before High Court, this is called as a tax case appeal. So when the matter comes up, your condemnation application will first be listed on the first day of hearing. So the High Court will look into the reasons that you have cited for not filing the appeal. If they are satisfied, suppose there is a delay of only 2 months or something, the court themselves will say, okay, this can be controlled. But suppose there is a substantial delay, say 300 days or 400 days, they will ask the other side, which is the department, to say whether you have any objections regarding this condemnation application. If at all they have some objections, they will be given an opportunity to file their counter affidavit with respect to the condemnation application that you have filed. Now, only when your condemnation application is disposed of, will your matter even be listed for admission before the High Court. So till then, your matter will not be listed for hearing it on merits. Now let's say when your appeal is listed, your condemnation application is disposed of, where they have allowed your condemnation, then your matter will be listed. If your condemnation application is dismissed with the threshold itself, then the remedy that you have is to file an appeal before the Supreme Court. Now, when you file the appeal before the High Court, that, like I said, there should be a substantial question of law. The last fact-finding authority is the tribunal. After that, you cannot introduce any new fact, you cannot introduce any new evidence if you want to. Suppose you were stopped from raising these new facts and evidences before the lower authorities and you badly want a remand, then you can cite these reasons, you can mention why you are not able to produce these before the lower authorities, and if the court feels that your reason is correct, then they can remand. Otherwise, no, you cannot do that. So there should be a substantial question of law. What is substantial question of law? We will come. Now, so when the High Court hears your appeal, that is a tax case appeal, they have to decide on the substantial question of law. The substantial question of law will be framed by them. And during the course of hearing also, the High Court can themselves frame a substantial question of law. If they feel, suppose I have not framed it, the court during the course of hearing they feel that the substantial question of also should have been raised, then they themselves will frame it and they'll give you an opportunity to argue on those issues that they have framed. The delivering judgment. The High Court should decide the question of law so formulated and deliver such judgment thereof containing the grounds on which decision is founded and may award such cost as it deems. Suppose they feel that the appeal that I have filed is frivolous in nature, it does not have any proper substantial question of law, and that I have wasted court's time, then the court has the power to impose cost on me also. The powers of High Court when they decide an appeal, they can decide on an issue that is not be determined by an ITAT. They can also decide on issues which have been wrongly determined by an ITAT. Now, what is substantial question of law? See, there could be some issues that requires further arguments. Something that is not being decided or settled by a Supreme Court, or an issue that has alternate views of different High Courts, or something that seriously affects the legal rights of a party. If that is the case, that issue becomes a substantial question of law. A question of fact cannot be raised in an appeal that you file before a High Court. So this is the chart which will basically say what are the 5 tests that one should put to determine whether you have raised a substantial question of law or not. It is of general public importance. It directly affects your fundamental rights, and that's something that's not been settled by Supreme Court, or something that is not free from difficulty, or something that calls for alternatives. These are the 5 tests that a court will see whether these 5 tests are satisfied in your case, and whether the substantial questions of law that you have raised satisfy these tests for them to even admit the appeal in the first instance. So like I said, an appeal before the High Court is maintainable only on a substantial question of law. Now, there could be a question of law and a question of fact. Both are not maintainable. That issue has to have a substantial value which has the capability of being a question of law. So this has to be determined. Now, there could be certain scenarios where a question of fact can become a question of law. Say for example, this particular issue has a mixture of both fact and law. That scenario, can it be framed as a substantial question of law? Answer is yes. Say I have filed some evidences before the ITAT. ITAT did not consider those evidences in a proper manner and they have arrived at the conclusion. Or the evidences they have considered and arrived at a conclusion which is not even relevant to my case. If these are the situations, then this becomes a question of law because my evidences were not considered in a proper manner and they have arrived at a conclusion which is completely not acceptable and is not according to the standard. That is the case. This question of fact becomes a question of law because it has both mixed questions of fact and law, and this can be framed as a substantial question of law. Another situation is generally any inference from certain facts is a question of fact, but if a finding is given by a tribunal without properly rejecting the evidences that are filed, this would also amount to a question of law. This is another scenario. So like I said, this judgment in the case of Ram Sharma versus ITAT, the court would have held that anything that substantially affects the rights of a party, that should be considered as a question of law and framed. See, a question of law, if it pertains only to the particular facts of the case, it will not be a question of law. That question of law should be in discussion before various High Courts, that should have different views from various High Courts. If that is the case and if it is not settled, then it becomes a question of law. If the question of law arises only in my case, which is not actually applicable to any other case, then that cannot be framed as a substantial question of law. So there are some judgments that we can deal with. So this is a Supreme Court judgment in the case of Shivraj Gupta versus CIT. This is a case where the court will say that once a substantial question of law is framed and when a judgment is delivered by the High Court, they have to either affirm that the substantial question of raised is correct or they have to negate it. They cannot simply say, no, this is not a substantial question of law, this is only a fact, therefore I will not. They cannot decide that in single line. They have to give reasons as to why they feel that the issues or grounds raised is not a substantial question of law. And there could be scenarios, like I said, during the course of the arguments, during the course of the appeal proceeding, if the court feels that this question of law should also have been raised, then for them to frame that question, they have to be satisfied of two things. One, this question of law is necessary or crucial to decide the facts of the case, and two, they also have to record reasons for it. Unless these two things are satisfied, they cannot frame a question of law on their own. This is another case where in ACCT was GlaxoSmith. So this is ideally a case where a writ petition was filed under 226. Why? Because the time limit within which they have to prepare an appeal before the High Court had expired. It was basically time bound. And in this case, there was a substantial delay for about 1,000 years. So here they thought that instead of going on an appeal and having my continuation application rejected, let me try my way through a writ petition under 226. There the court would have said, just because the only issue that you have is that I could not file the appeal for being in High Court. For this instance, you cannot file a writ petition and waste our time. So therefore, in this case, the court would have said, the only remedy that you have is the appeal remedy before High Court. Because you have not utilized this, you don't come and do forum shopping here, is what the court would have said. This is another Supreme Court case, CIT versus Rashtradoot. So here also the same thing, the court will say that when you are rejecting, this is a case where the revenue would have filed an appeal, framing substantial question of law. And in this case, the High Court would have simply rejected that these questions are not correct, therefore we are not entertaining your appeal. There, when the matter travels to Supreme Court will say, absence of any reason or a recent order as to why you feel that the tribunal's order does not suffer from any illegality, or these questions that have been framed with the revenue are not substantial in nature. If you don't give such reasons and you simply reject it, then this is not correct. So therefore, they will remand the matter back to the High Court and ask them to do a de novo proceeding. Now, generally, after you file an ITAT, after you receive an ITAT order, and if you feel there is a mistake apparent on record, then you can file an application for rectifying the mistake under 254(2). Now, in this case, 254(2) would have been preferred. 254(2) is a very limited power. Now, the assessee here would have thought that because my application is pending, let me not file my appeal under 268 till my application is disposed of. There, the court will say, you can do parallelly. You don't have to wait for the disposal of the 254 application because there is no timeline granted for them to pass the order. So therefore, if you wait till then, because of the waiting period, we cannot say that we can control the delay for you. So this can happen parallelly. That is also very restrictive in nature, whereas 260 is very wide. So whatever issues you have raised in 254 can also be raised in 268. This is what the court would have done. So this is also another case which is very important. Now, this case would say, generally when we file an appeal with a condemnation application, the court has to see whether there is a sufficient reason or not, and there are certain cases where my appeals have been dismissed at the threshold. This is a case where the department has filed an appeal with condemnation. The court would have dismissed it. Supreme Court would say that when a department is filing an appeal with a condemnation, don't reject it. You impose cost on them. See, there could be a substantial merit in that matter, and it could also be a matter of high stake. So when a department is filing an appeal with condemnation, don't reject it, impose cost on them. So by this we come to understand there is always a difference between the department and us. So when we file an appeal, yes, they have the right to dismiss it at the threshold, but when a department is filing, the Supreme Court itself says, don't dismiss it because it should be of a high stake matter as they are going on an appeal. And in the substantial question, there is another judgment of Supreme Court also, where they say that with respect to the question of law that is framed, you are citing few High Court judgments which gives different view, which gives a view that is in your favor, but the High Court before whom you are arguing, the court feels that this view is not acceptable to us because of territorial jurisdiction. They are not bound by that. They say this view is not acceptable to us, therefore we are going to decide this case against you. So there, the Supreme Court will say, even if you are not bound by the other territorial jurisdiction decisions, if you want to reject it, give a reasoned order and a speaking order. You cannot merely say that I am going to reject it. Now, let us just take an illustration as to how you should frame a substantial question of law. Now, let us take a scenario where this assessee is a charitable institution. So they are registered under 1280 and they will be claiming exemption under section 11. So this institution is being set up for development of some IT infrastructure in the state. They have been also formulated by the particular state government. Now, my job, the assessee's job is that I should develop IT infrastructure and I should lease it out to IT companies for them to perform and go well. So I am doing that. So I do the infrastructure and I lease it out to them. My case would have been selected for scrutiny and the AI would say that you renting out these premises nothing but a commercial activity. So therefore you are hit by proviso 250, where they say that a charitable institution cannot be engaged in this trade, business or commerce unless it is in advantage of general public. So there they say that you are doing commercial activities, therefore you should not be eligible for this exemption. Against this I go to CIT. CIT also upholds the order and matter goes to ITAT. ITAT also upholds the A1 CIT's order. I give necessary evidences also saying that what I am doing is charity in nature. In fact, for to be commercial in nature there should be some profit motive. I am not doing anything of such sort. I am charging very nominal price. So therefore, you cannot consider my activity to be in the nature of commercial in nature. And also, I am doing this because the government has asked me to do. The government has asked me to develop this infrastructure in the state. So therefore, my activity is nothing but charitable in nature. But however, ITAT does not accept my submissions. And also, at that point in time, they rely on Outer judgment, Ahmedabad Development Authority, and say that any charitable institution that is engaged in trade, business, or commerce, they should not be, they are not considered as any charitable institution. So citing Outer judgment and simply by saying that renting or leasing of premises is commercial nature, you are hit by proviso 250. So therefore, I am denying the exemption. Now this is the case. So in this case, how do you draft a tax case? So this is the format that we have just put up. So before the Honorable High Court of Madras, PCA number so and so. So you have to here mention the who's the appellant and who's the sample format. So for you to file a tax case before the High Court. Before the Honorable High Court of Madras, then you should mention your PCA number. Then what you are appealing against. Then you have to mention the party's name. You have to mention their address. So the first portion will be the statement of facts. Statement of facts will ideally cover what all happened before the assessing officer, before the CIT and that. Before the assessing officer and CIT, whatever contentions that you had raised and whatever order was passed, that has to be stated in a very brief manner. You don't have to be very elaborate about it. And when it comes to ITAT findings, we elaborate, see on what grounds, to elaborate on what grounds they have rejected your appeal. Then comes the grounds of appeal are nothing but those which help you to frame the substantial question of law. So in this case, the grounds that we have raised is, like I said in the facts, I had given necessary documents to prove that I am not charging any profit and it's only on cost-to-cost basis. But despite that, they said that I am doing a commercial activity and therefore I need to proviso. This becomes a mixed question of law and fact, like I explained earlier. But this can be framed as a substantial question of law. Then they simply in one line they say that renting out is itself a commercial activity without giving any reasoning. So this becomes a substantial question of law. And they rely on the Supreme Court judgment order and say that you are also similarly placed like those assessees mentioned in order. So therefore, your case, in your case also exemption should be denied. This will also become a substantial question of law because they don't clearly say how the Supreme Court judgment is applicable to you. Okay. So generally, each office practice is very different when you file an appeal. Some offices only point out the grounds that you want to raise. Some offices, with respect to each ground, they will make elaborate submissions, like a written submission. This is the ground. These are the points that I want to raise. So this can be elaborate, or you can also make it as a point wise. Now, substantial question of law, like I said, emanates from the grounds of appeal. So in this case, we have stated that whether in the facts and circumstances in the case, the Honorable ITAT was right in holding that the appellant would be hit by proviso 250. Then whether in the facts and circumstances, the appellant was right in applying the Supreme Supreme Court decision of order. So this is how a substantial question of law should be framed. Now, you will frame the substantial question of law in your appeal, and when the matter comes up for admission, the judges will look into your appeal. Sometimes, so the thing is, they have to frame the questions of law. In fact, if you see the lower courts, what happens is that you should only tell them the issue. They themselves will frame the question of law. Whereas in High Court, in the appeal, you will mention the substantial question of law. They will go through it. And if they feel that there is a repetition or something, first they will see if it is a fit case. If it is a fit case, then they go into your substantial question of law. If they feel, okay, you have a case, therefore this appeal can be admitted. But they need not admit whatever question of law that you have raised, they need not admit it like that. Sometimes they may feel, you are only repeating one ground again and again. Generally how we do to extend paragraphs and all. So if they feel it that way, they will concise it and make it as 2 substantial question of law or 3 substantial question of law. So it will be framed by them. And only on those substantial question of law should you be arguing subsequently. So when the order comes out after an admission is made in your case, the order will also specifically say that the court has framed is following substantial question of law. So if it is changed from what you have already filed in your appeal, then you have to go by whatever the court has framed. And during the course of hearing, any additional question of law, if they frame, they will give you an opportunity. So therefore, I will argue saying that this is the case. The revenue will argue saying, no, this does not even, it's not even worth as a question of law. This is nothing but a question of fact. So therefore, this should not be it. This is how the arguments will be. Once you file your appeal, what happens? Procedure of hearing the cases before High Court. So, after a tribunal's order, the appeal should be heard by a division bench. This is provided in 260. So, appeal should definitely be heard by a bench which is not less than 2 numbers. Now, there could be scenarios where one judge will have a different view than the other. So, if they don't come to a proper meeting of mind is not there between the 2 judges, what happens is your case will be referred to another single judge, who is the 3rd judge. Now, depending on what he decides, on that majority, judgment will be delivered to you. So, this reference to the 3rd bench is ideally called as reference to a larger bench, though ideally it is not referred to maybe 3 judge or 4 judge, it will be referred to another single judge only. But this is generally referred to as reference to a larger bench or reference to a 3rd judge bench. So, this is how the general connotation is. So, with this we complete High Court appeal. Anybody has any doubt? So next is the appeal that lies before the Supreme Court. So timelines are prescribed in the statute for every appeal that you file before each appellate authority, but likewise it is not there for Supreme Court. For you to file an appeal before Supreme Court, you should take leave of the Honorable High Court where you have got a case against you. This High Court will write and tell you that yes, this is a fit case for you to file an appeal, then only you can go to Supreme Court. Now, generally there is no timeline also for the High Court to give you that permission, but going by the Limitation Act, generally there are also cases to say that 1 year is the timeline within which the court should say that this is a fit case for you to file an SLP. If that doesn't happen, then you have to keep mentioning before the court that I want to file an SLP, please grant me permission. This is the general procedure that goes. So, section 261 is the relevant provision under the Income Tax Act. When can it be filed? Like I said, once the High Court grants the permission. When should the appeal be filed? No time limit. As and when you get the permission of the High Court, you will file. Applicability of CPE. So, Civil Procedure Code is the act that tells you how an appeal should be filed or what is the procedure that should happen when an appeal is being taken into consideration. For example, like you can inquire anybody that you want. You can ask for any evidence that you need. All these are there. You can summon any person. So these are all the provisions that are prescribed in the CPC, which is ideally applicable to an appeal when it is decided by a Supreme Court or even High Court. Then cost of appeal to the Supreme Court, this will be decided by the Supreme Court only. Delivering judgment. So the Supreme Court, if it can reverse the order, it can modify the order, or it can remand the matter back to the High Court saying that this was not considered in a proper manner. Effect order, so suppose Supreme Court reverses an order of High Court, then an order giving effect to should be passed in consonance with the Supreme Court order by the assessing officer. Now, when you file the appeal before the Supreme Court, it will be filed as a civil appeal number. So there are stages in Supreme Court as well. Once the civil appeal is admitted, then it will be converted into a special leave petition. There are instances where at the stage of civil appeal itself, the matter will be dismissed. So then it cannot get converted to an SLP. So first stage is it will be numbered as a civil appeal. Then once it is admitted, saying that yes, this is a case that requires hearing, then it will be converted into an SLP. So the next topic that we will be discussing is the judicial discipline, doctrine of judicial discipline. So doctrine of judicial discipline generally means that the orders of the higher authority should be unreservedly followed by the lower authorities. This is what doctrine of judicial discipline in general means. So there are three doctrines in this. One is the doctrine of res judicata, doctrine of estoppel, doctrine of binding precedents. Now, what is res judicata? So in simple terms, res judicata means some matter is already decided by a court of law in respect of some person for some issue. For the very same issue, another person should not go to that court and say that this also should be litigated. So, there the principle of res judicata applies. When it is already decided, don't come and waste court time by filing the same issue and you want to litigate. So, three things that we notice. One, they don't want to waste court's time. Two, they don't want to waste people's money, parties' money. And third, by bringing in the same issue, you might want to arrive at a different conclusion, which is not correct. That will defeat the purpose of legal system. So that is why doctrine of res judicata is generally applied. Now the question is, can doctrine of res judicata apply to income tax proceedings? The answer is no. Res judicata is not applicable to income tax proceedings. There are judgments to say that assessment done for that particular year is applicable only to that year. You cannot apply it to some other year. So this case of installment supply versus Union of India, there the Supreme Court will say that res judicata is inapplicable in tax matters, and the general rule is not to apply this doctrine. So the court will say that tax matters there is no question of res judicata because each assessment is final only for that year and it does not govern later years. Likewise, in another judgment, that is Radhoswamy Satsang case, there the court will observe that each assessment is a separate unit. Decision in 1 year may not carry forward and hold for a subsequent year. There the court held the rule of res judicata as embodied in section 11 has no application. Each year's assessment and decision is hence final to only that financial year and hence so determines the liability of the assessee of that particular financial year or period. So therefore, the Supreme Court has made it very clear that doctrine of res judicata will not apply to income tax proceedings because the law laid down for that year is applicable only to that year and it cannot be carried forward to any other subsequent years. But there is something called principle of
issue in expenses are exempted income. Assessing officer after issuing the matter to assessing. The same matter again for this another assessment. Here is
it was decided in your favor in the previous year, but in the second year their issue is
for consequently so many years.
correct. Now
4 or 5 years they are receiving.
that is what I am coming to next. There is something called rule of consistency. Okay. So rule of consistency means suppose I am I have been flipped.
Along with that assessment order, they will also ask if there is any applicability.
So they are issuing the rules.
No, sir. In that, they will write that whether you whether the same matter has been pending in any other assessment year. If yes, please submit the closure order. So you have to give the closure order of that letter if it is in your favor, assessee's favor. So on that basis also they will take the judgment and they will close the other assessment years. This is what they will ask, because if you read that assessment, the notice which you got in for the next year, subsequent financial year, in that they will ask whether the same has been decided on the previous year. Yeah.
So if that is the case, you can definitely produce your judgment that have been decided in your favor and annex it. Then they may drop the proceeding for that particular thing. So there's something called rule of consistency where you have been claiming something and you have also been allowed. for so many years. But then, particularly for 1 year, they say, no, you're being showing this income as short-term capital gain, but whereas it's nothing but income from business or profession, so therefore I'm going to treat it that way. There, the court will say, rule of consistency will creep in there. They say, for all these assessment years till date, I have been following this method and I have also been allowing you. For this year alone, you cannot show a different treatment. You cannot consider it to be income from business or profession. So therefore, rule of consistency will apply in such a case. So rule of consistency is applicable in income tax proceedings. But Supreme Court has said rule of res judicata is not applicable. If you see, rule of consistency in fact emanates from res judicata only. So if we go by that, then res judicata is also applicable to income tax proceedings. Then the next doctrine that we come to is estoppel. Estoppel means, see, maybe I have stated something today, but after 2 days, I am giving you a contrary view. I am stating something that I had stated contrary in the past. That I am not supposed to do. We give a very common example. Say there is a notification issued. Based on the notification, I have applied for the job. It's a serviceman. I have applied for a job. I did not get the job. Then I go and challenge the notification saying, this notification is arbitrary. This is not correct. This is not issued in accordance with the standard. The court will say, you, based on the notification, have applied the job. Just because you didn't get the job, now you cannot come and say this notification itself is invalid. So this is called doctrine of estoppel. Now the question is, can this doctrine of estoppel be applied in income tax cases? The answer is no. Now, see, for ruling the assessment proceedings, I give certain evidences, or my authorized representative gives certain evidences which I was not aware of. Then based on those evidences, additions have been made, which is not correct. Those evidences first, they are not correct. Then during the CIT appeals, I say, no, these evidence should not be considered, it is wrong. I am taking back, I will give you fresh evidences. CIT will say, you are stopped from doing that because you only gave it during the assessment proceedings. So therefore, you are stopped from taking it back and giving a different one. That this matter would have gone to High Court. High Court will say, doctrine of estoppel will not apply to income tax proceedings. Under the Income Tax Act, the assessing officer should assess the right amount that an assessee is liable to pay for that year. So by bringing doctrine of estoppel, you cannot make him liable to pay a tax something for which he is not even liable to. So therefore, doctrine of estoppel will not apply to income tax proceedings. The next principle is binding precedents. So doctrine of stare decisis means to stand by already upheld decisions or to uphold precedents. So if something has already been settled by a higher authority, I am duty bound to follow it. If Supreme Court decides a law, under Article 141 says that Supreme Court is the supreme power, it has the supreme power, and any law declared by the Supreme Court should ideally be followed by all other authorities. So therefore this is called doctrine of stare decisis. Now, through some case laws, let us understand the binding nature of Supreme Court decisions, High Court and tribunals. So like I said, by virtue of Article 141, whatever decision the Supreme Court takes, it is binding. Now whether, with respect to High Court decisions, let us analyze different scenarios where a High Court decision is binding or not. So like 141 that is provided in the Constitution, there is no separate article which says that a High Court order is binding on the other High Courts or the lower authority. There is no separate article. So therefore, we are inferring all this from judgments. So in the case of East India Commercial vs. Collector of Customs, that the court will say that law declared by the highest court in the state is binding on authorities or tribunals under its superintendence and they cannot ignore it. Now, we are under NFAC. So now a question may arise, I am in faceless assessment. NFAC sits in Delhi. So what kind of cases should I refer to for them to even accept? Now I am a person sitting in Chennai. So should I cite Delhi judgments or should I cite Bombay judgments or only chartered court judgments should I cite? So these doubts will arise. That the court has held that wherever your jurisdictional assessing officer is sitting, cite those territorial jurisdiction judgments. So therefore, if my jurisdiction assessing officer is sitting in Chennai, I will cite Madras High Court judgments. If it is Bombay, I will cite Bombay High Court judgments. Okay. Then in the case of state of AP vs. CTO, the court will hold if any authority or the tribunal refuses to follow their own jurisdictional judgments, appellate authorities' judgment, then they will also be subject to contempt proceedings. So this is such a grave offense. They consider as a grave offense that if you don't do it, then contempt proceedings will be initiated against you. So if it is a CIT appeal order or a tribunal and if they don't follow it, they may be called by the court and they may be initiated with contempt proceedings, which is actually a grave offence. Then the famous case is the Union of India versus Kamalakshi Finance. There the court, Supreme Court will say that higher authorities order is binding on all lower authorities order. Now let us say that I have a favourable order to lifetime. The revenue has filed an appeal before the High Court, but they have not obtained any stay. So therefore, then for some other year, my case is picked up for scrutiny by the assessing officer, then he makes the addition. I file an appeal for the CIT. I say that he has not followed the doctrine of judicial discipline because I have a favourable order till ITAT, but however he has not considered it and he has made the addition for the very same issue. There, the department cannot take a protection saying, I have filed an appeal before High Court, so therefore this issue is not settled. Kamalakshi Finance will say, unless there is an order of stay given by the higher authority, the order given by the last higher authority will stand good. So therefore, unless High Court grants a stay, the order of ITAT will remain good. Therefore, that order has to be followed by the assessing officer or the CIT levels who are the lower authorities. Now, binding nature as regards different benches of the same High Court. Now, there is this case of CIT versus Thana Electricity Supply of Bombay High Court. There they say that a single judge or a division bench order of a High Court is binding on the single judge of the same High Court. Therefore, I am bringing a matter before a single judge. He grants an order in my favor. Then some other person is bringing an order before another judge. Portfolio changes, some other person brings an order before another judge. He quotes the judgment where I have won, saying that there is a similar issue where this judge has given a favourable order. The other single judge is bound to follow it. He cannot differ. Suppose he wants to differ, matter should be referred to a larger judge. How the process goes is, it will be taken up to the Chief Justice of the concerned High Court. They will say that there is a difference of opinion, so therefore this has to be placed before a larger judge. In that case, it will be heard by a division judge. The Chief Justice of the Madras High Court or whichever court it is, they will assign a particular bench to take up this issue and it will be decided. So therefore, once a single judge order is there and the other judge wants to give a different view, he cannot do that. He can only refer it to a larger judge. Likewise, for a division bench also, if there is a division bench order and the other division bench does not want to follow it, it has to be referred to a larger bench, it should be a three-judge bench if it is a High Court. Then, so binding force of decisions of a High Court extends beyond its territorial jurisdiction. So whether a judgment given by Madras High Court is binding on a Bombay High Court or a Delhi High Court, the answer is no. It is no. Only the authorities who are within the particular territorial jurisdiction are bound by it. It does not extend to other territorial jurisdictions. Yes, it has a persuasive value, but other than that, it does not have the binding factor. So this has also been elaborated in CIT versus Thana Electricity Supply. And suppose if there is a conflict of decision between two coordinate bench, then in that case also the matter will be referred to a larger bench. So when a precedent ceases to be binding, when you should not apply these decisions in your case. So this has been elaborated in the Andhra Pradesh High Court in the case of CIT versus BR Constructions. There they say that these are the situations that they have listed out. When the order is reserved or overruled by a higher authority, when it is affirmed or reversed on a different ground, when it is inconsistent with the earlier decisions of the same rank, when it is sub silentio, that means it is a non-speaking judgment, in that case that order is not bound, when it is rendered peremptory. So these are the 5 instances where they say that this binding nature will not be taken seriously. Next is obiter dicta. Is it binding or not? Obiter dicta is nothing but a general expression of opinion that a judge gives in his case, which is not relevant for them to arrive at the ratio decision. So this principle of law may not have been on the opinion that they have given. So in that case, should everything that the Supreme Court says, is it binding on all authorities? The answer is no. If that observation that is given in the Supreme Court judgment, it is no way in relation to the ratio decidentis that they have arrived, then you don't have to take in everything. This Bombay High Court says it would be incorrect to say that every opinion of the Supreme Court would be binding on the High Courts in India. Only the opinion expressed on a question that arose for determination in a case is binding. Otherwise, it is not. So next, we'll come to the writ jurisdiction. So writ is filed both before the Supreme Court as well as the High Court. So before the Supreme Court, the concerned article is 32. For High Court is 226. There are many cases where the Supreme Court entertains a petition bypassing High Court. That doesn't happen. So, but in rare cases, yes, Supreme Court takes up such things. So, what is a writ? It is nothing but a formal order that is issued by a court. It is in any order or warrant or direction that is issued by a Supreme Court or a High Court. There are 5 types of writ. One is habeas corpus, mandamus, certiorari, prohibition, and quo warranto. So as far as people who are in the tax side, for them habeas corpus, quo warranto may not be applicable. Certiorari is basically you are calling the order, you want to call the order that you impute against and you want to quash it. So this is called certiorari. Mandamus is something that you want the authority to do something. So therefore you are asking a direction from the court to make an authority to do some particular act. That is called as mandamus. Then prohibition is where if somebody is prohibited from doing a particular act, you will file for this writ, asking the court to prohibit that person from not doing such an act. Quo warranto is basically where a person, he acts beyond the power that he has. So on what role are you performing this function? That is called as quo warranto. Now generally the writs that we file here is when you are affected by an assessment order. So the writ that you will file is a writ of certiorari, where you want to call the order and you want to have it quashed. If you want to quash the order, so that is only certiorari. But if you want any direction, say that maybe you are not granted personal hearing, and if you want that to be done, it's a certiorari mandamus. So that is the writ that you will file. So generally, income tax matters or any matters, the common writ that we file is certiorari mandamus, where you want to quash the order and you want some direction from the court directing the authority to do one particular act. Like I said, Article 226 empowers the High Court to issue written directions primarily within their own territorial jurisdiction. But whereas under Article 32, the Supreme Court has the power to exercise its power over all territorial jurisdiction, because that is the Supreme Court. Then there is also one other writ called Article 227 that not many people will know. This 227 is a supervisionary power of a High Court. So this power is very restricted. Why? Because the High Court has the power only to revise an order of a tribunal or a lower court. Other than that, they cannot exercise those writs that we had mentioned earlier. That power they do not have under 227. That lies only with 226. So therefore, 226 is very wide. 227 is limited only to the purpose of revising an order of a tribunal or a lower court. Now, writ jurisdiction in High Court, generally when do you prefer in income tax? So these are some 5 scenarios that we have put. One is section 147 and 148. This is basically reassessment proceedings. All of us find that we file a lot of writ because so many inconsistencies are there when a notice is issued. Then 132 is search proceedings. So search is not conducted in a proper manner. If you want to challenge the legality of the search, you file a writ. Section 220 is where you don't pay your demand as per the demand notice and you are issued a notice under 226 where you are liable to pay interest. In such a case, 220 can be filed depending on the scenario. 254 is where you have filed a rectification application and that is not passed in a proper speaking order. So if that is the case, then you can file a writ. Then section 201 is where an assessee is considered to be an assessee in default. So there are certain circumstances where you can file a writ if you are agreed by the 201. Now, we have just listed out certain situations where a writ is preferred against a reassessment proceeding. So one is barred by limitation. So say that we all have time, they all have time limits within which they can initiate reassessment proceedings under the new law, 3 years and 10 years, which is now being changed again by the Finance Act. So suppose they don't issue that notice within the time limit prescribed, yes, it is barred by limitation and that is a valid ground for filing a writ petition. Next is the objections not dealt or non-passing of a recent order under 148A. The new procedure is that, yes, 148AB notice will be issued to you. This is a so-called notice issued to you saying that we have information which suggests that income charges will have to escape assessment. You have to give your reply. Upon seeing your reply, they have to pass an order under 148AD. So this 148AD should be a proper speaking order. They should consider your submissions and we should pass the order. That is not so. It is a ground for filing a writ at that time. Then approval of a specified authority. See, there are certain scenarios where you don't have to go through this 148A procedure. For example, search cases and all. You don't have to go through. You can directly issue a 148 notice. But to issue that, you should obtain a prior approval of the specified authority. If that is not being followed, at that instance, you can file it. Then procedure under 148AB or 144B. 148AB will ideally say that I am giving you time of 7 to not beyond 30 days to file your reply. If the timeline is not granted, then yes, you can file it without jurisdiction. Now, if you see writs are filed saying that 148 notice should be issued by the faceless assessment officer. But what is happening is that as per 151A, there is a notification that is issued saying that from 148A notice stage, the JO should not issue. It is the faceless assessment officer who should issue notices. But what they are doing is, this is also being issued by a jurisdictional assessing officer. So there are plenty of cases that are filed in all high courts regarding this JOF, they call JAO form. So this issue is still pending, and the matter is actually pending before Supreme Court. Exaware is the first judgment of Bombay High Court where they said that this is against the statute under 151A.
Usual cases, they will not take whatever submissions we do under 148AD or whatever, they have to issue, they will issue notice under 148. So they will not consider any of your submissions during the inquiry stage. Whatever inquiry you do, we cannot. The only procedure we have is to go for petition against.
They have made up your mind that they are going to.
Right.
The second is the non-existing information. So the statute itself will say that you should have an information which suggests that income charge will escape assessment. If there is no such information like that and they still want to proceed against you, that could be a valid ground for you to file it. Then the other one is change of opinion. This change of opinion has been a relevant factor for a very long time. So suppose this issue merely means that there is a particular issue for which I was already subject to adjudication during my original assessment proceedings. For the very same issue, if they want to initiate the assessment proceedings, it is nothing but a mere review of the original assessment order, which is not permissible under the statute. So for this reason, you can file a writ and have the proceedings itself quashed. Then, if you don't follow the circulars or notification, that can be a ground for a writ. Then, like we discussed, if an email is notices or order are not sent to your registered email address, then and if you have not received it, then you can file a writ saying that I have not received it and go back to the stage. Suppose it is beyond the time limit.
They will again refer it to
Yes.
Back to the same station. Back to the same station.
So you will be escaped from paying that tax for that point.
It's just a.
They are just delaying the price.
You can just defer the taxes.
Now, writ jurisdiction under 132, like I said, search proceedings will happen. So, for a search to happen, the officer should have a reason to believe that that there is some material evidence that can be available in the premises. So, therefore, I am going to conduct search. If that reason to believe is not recorded or satisfied with the assessing authority, then it is a good case for you to file a writ. So, this reason to believe, though it says that it records the reason to believe, unless that reason to believe is applied to you, you will not know what it is. So therefore, if they only merely say that yes, I have recorded the reasons and they come and show it, it's not correct. Merely recording will not satisfy any purpose unless they serve it to you. So there have been instances where we have filed a writ saying that there is no reason to believe because they have not recorded any satisfaction one. There the department have argued saying the statute only says I have to record my reasons to believe, which I have recorded. There the courts have held that merely recording will not serve any purpose unless you supply it to them. So don't have to wait for them to ask. You supply it. When you issue a notice that I am going to conduct such proceedings, you supply the reasons also. Now, there are certain notices that once a search is conducted, notices are issued under 153A on the person on whom search is conducted. And if at all they find some incriminating material against some other person, notice is issued under 153C against the other person. Now, the time limit for you to complete assessment proceedings depends on the time when this particular judicial assessing officer has given those information to the other officer who has jurisdiction over the other person. So you have to calculate all that, and if it is not within the time limit, that is a ground for filing the release of assets. Now, generally during search proceeding, they will take your belongings, they may not even give it to you. There is a reasonable time in which they should give it to you, but they will not. That is the case, and you want your assets back, then you can file a writ for lifting of those arrangements. Now, writ jurisdiction under 220 is where you don't pay your demand, because of which they will issue a notice under 220 saying that you are liable to pay some. So, what are the grounds that you can file a writ? That is, you have filed a stay application before the assessing officer, and that could not have been disposed of. So, pending that, they might issue a notice to you. That is wrong. So, that is a good ground for filing the writ petition. Now, if you do that, what will happen is this notice will go, but he will pass on after that. Then this should not be done without giving you an opportunity of being heard. And CPE circular will say 20%. Once you pay 20%, then it can be granted. But if they don't follow that and they ask you more than 20%, if that is the case, then you can file it. And if they refuse to exercise their discretion, suppose you are able to establish a case on merits, like I have a good case and I have also been billing for the other authorities, and still they insist that you should pay 20%, that means they are not exercising their discretion properly. That can be a ground to file a petition. Then non-speaking order on a stay application. They simply say, no, there is a circular, you have to pay 20% without assigning any reasons. Then that is a ground for filing a petition. 254 is where you file a rectification application.
And it also be filed against provisional attachment during the
Yes. Unless the provisional attachment is not done in the manner that is prescribed, yes.
No, if it is done in the manner containing all the approvals, BCC, and everything, still if the SSC is reviewed, let's say provisional attachment is done of one particular asset and whose value is much more significant than the value of the demand, right? So SSC wants that particular attachment to sort of, if let's say for an example that provisional attachment relates to shares of some company. So if that provisional attachment is released, ideally he can sell those shares of the company and he can pay back the demand or something he can do for liquidating. Can that be filed? Can writ petition be filed against that provision?
Definitely. It can definitely be filed. But what will happen before the
Order, but still, order everything has been followed, like all the necessary approvals have been.
I agree. Now I understand. So definitely it can be filed, but you will arrive at a settlement in the writ court. This will be lifted, but equivalent to the demand amount that you are liable to, you have to give some guarantee. This is what will happen when you file a writ before the court. Now, under 254, when you file a rectification application, you are aggrieved against the order of contract, you file a rectification application and that gets rejected, not on proper reasons, then yes, that is a ground for it. And if you are not permitted to file those additional evidences that you can before the ICAI, that is the case, yes, you can file for it. Under 201, where you have not deducted, periods that you are required to, then you are considered as an assessing in default. So there are three grounds that you should see when you want to challenge a 201 order. There is something that is barred by limitation, territorial jurisdiction, and the tedious officer has acted beyond the powers that is vested under 201. So there is this judgment of Bharati Airtel versus Union of India. So here is a case where the petitioner, he would have challenged the tedious proceedings on the ground that the time limit is prescribed. At that point in time, the time limit is prescribed only for a resident, where you have to initiate proceedings or conclude the proceedings under 201 within a period of 7 years. There would not be any time limit prescribed in case of a non-resident who payment is made. So therefore, with respect to a non-payment, non-resident, the reasonable time that is generally being decided in various courts is 4 years. In this case, what would have happened is the 201 proceedings, this is with respect to a non-resident, 201 proceedings would have been completed beyond the period of 4 years. Therefore, the petitioner will argue saying this is beyond the reasonable time, so therefore this proceedings should be quashed. That the court would have quashed, saying that this is beyond a reasonable period that has been laid out by various decisions, so therefore this will be quashed. Now, by this amendment that's been brought in by the latest Finance Act, they brought in a timeline saying that 6 years from the end of the financial year or 2 years from the date of corrected statement, whichever is earlier. So now this has also been sorted. How do you draft a writ petition? So we have again put a format. So this writ petition will come under special original jurisdiction before the High Court. So this is the general format that everybody uses. You have to affidavit filed with the petitioner. So the first paragraph is as anything that you file an affidavit that whoever is filing the affidavit. Then the third paragraph should contain the prayer that you want to be present in the petition. Suppose you are challenging the assessment order, the writ of certiorari mandate is calling for the records related to so and so order, quash the same, and directly assess it. The respondent, who is the assessing authority, direct them to do this particular matter. So this will be your prayer. Then the facts should be elaborated. Whatever is necessary for you to get an order in the writ, everything should be stated. Then grounds. So grounds are basically, you will raise only on jurisdictional aspects of violation of principles of natural justice. Merits, you should not get into the writ petition. No court will get it. So therefore, your grounds should specify very clearly on jurisdictional aspect. Yes, you can take the grounds on merit. There are some judges who know income tax. They might ask you what the case is, and they might also see whether you have a good case on merits, so that they can actually remand your matter. So if that is the case, yes, you have to mention on grounds on merits as well, but your primary focus should be on jurisdictional aspect. And if you want to obtain a stay of the order, then that is a separate prayer that you will seek for. Stay of the proceedings and any further proceedings with respect to the assessment order. Now, after you receive the assessment order, penalty proceedings will be initiated. So therefore, unless you seek a stay of the assessment order and further proceedings with respect to that included order, nothing can happen. So therefore, stay is very important. So therefore, when we argue a writ, when it comes up for admission, most likely we will aim to get a stay because the other side would want to file a counter affidavit. So therefore, when we argue, we will ask for stay. We will press for stay, and sometimes the court will encourage. They say, okay, this seems to be a valid case. We can grant you stay. But there are some cases, sometimes the court will say, let them file their counter. Till then, status quo will be maintained. Status quo is nothing but till now no recovery is done. So therefore, till the next set of hearing also, we will maintain the same status. So obtaining a status quo is akin to obtaining a stay. But if a stay is granted, you are very secure. Okay, I have a stay, they will not do anything. And also, so there are certain things that we have learned. Like a passing remark, the judge will say, okay, maintain status quo. This will not be recorded in the order. So the daily orders will come. Once we see the daily order, we will see that this maintaining of status quo will not even be recorded. The department, they will ask the department to go inform. They will also not inform because it is not recorded in the order. And immediately recovery proceedings are happening. This has happened in many cases. So therefore, if that is so the next topic that we will be dealing with the prosecution proceedings. Recently, what is happening is the prosecution proceedings are being initiated against many assessors. So this has become very regular, and I think this should not be left out that easy. You have to concentrate when you are received with the prosecution proceeding. So, Chapter 22, the Income Tax Act, with sections 275A to 280, they deal with offences and prosecutions. So, recently, the offences for which people have been prosecuted are non-compliance of certain provisions, evasion of tax, non-payment of TDS or TCS, concealment of income. These are the general offences. Now there are two types of offences. One is a cognizable offence and the other is a non-cognizable offence. This comes from IPC, Indian Penal Code. Cognizable offence means where the police can arrest you without obtaining a warrant from the court. Non-cognizable is where they can arrest you, they cannot arrest you without obtaining an order from the court. So, we have taken a specific section, that is 276cc, which mainly deals with willful default and not filing of return of income. So therefore the main element is willful default. Unless willful default is established, prosecution proceedings cannot be initiated. This is a non-cognizable offence. However, this is also subject to imprisonment of which ranges between 6 months to 7 years. Now, when a prosecution proceeding is initiated against you, practically what happens is you will be issued with a show cause notice saying that you have not filed your return of income that is necessary. So therefore, show cause as to why prosecution proceedings should not be initiated against you under 276cc. Now, say you are not there in station, you don't even receive this notice, you don't receive subsequent notices also. Then what happens? They will even issue a non-bailable warrant against you. Okay? For issuing a non-bailable warrant, you have to take permission from a magistrate court. They will take that warrant and they will serve it on you. The moment they serve it on you, you can be arrested at that point in time. So, if you are made aware that a non-bailable warrant is trying to be served on you, what you should do is, you should recall that warrant. Basically, when you know that an FIR is filed against you, you go ask for a bail before the concerned court. This is equivalent to that. So, you have to recall that warrant that has been issued to you. And if you have recalled it, you will not be arrested. So, to recall the warrant, the procedure is you should go to the concerned magistrate court. So, here in the Madras, it is the Economic Offences Court, Chief Metropolitan Magistrate, that is in APO. You should go to the concerned court, you should recall the warrant. For recalling the warrant, the accused must be present in the court, and sometimes they might ask you for some, they can ask you for some surety from you or from somebody else, and they, like any other police station, they will ask you to come and sign every month until the trial is concluded. So once the warrant is recalled, obtain a copy of the complaint. See what is mentioned in the complaint. If they were not able to establish that there is a willfulness in you not filing the return of income, then this is a fit case for quashing the said proceedings. To quash the said proceedings, you have to file something called as a criminal original petition before the High Court, where you can quash the entire trial proceedings that are pending against you in the lower court. Okay. The other thing that you can see is, say you don't want to go through all these processes. You want to compound the offence. And this is in fact a compoundable offence as per section 279(2) of the Income Tax Act. That is the case. You see in what way you can compound. File your compounding application. Now there is a Madras High Court judgment, recent judgment in the case of Kabir Ahmed Shakir versus ITO. So there the issue is with respect to non-filing of return of income for 2 assessment years. The assessee did not file for 2 assessment years. He was later on informed by the Income Tax Authority that why have you not filed it and why have you not replied to the show cause notice. He was living elsewhere. He says, I am not even aware that you have initiated such proceedings. And then he mails immediately saying that I have missed to file. I don't know what happened. My people who generally file, they missed to file. So therefore, but however, I have paid necessary tax along with the interest and penalty, everything I have filed. So therefore, now I am not able to file because portal is not permitting me. So therefore, this is the reason why I was not able to file. Then what happens? With respect to 2 assessment years, in 1 assessment he had considerable amount of tax that he needed to pay. For that year he had already compounded the offence. And compounding application was also already. For the other assessment, he thought no proceedings were going to be initiated because the tax amount is very minuscule. But apparently proceedings in fact had been going on, and in his case non-bailable warrant was issued. And he was able to recall the warrant. Then he went to the criminal Madras High Court to quash the proceedings. The judge said, I am not going to quash the trial proceedings. I will not do that. But I give you a liberty to compound the offence. Okay, so he will file a compounding application, but the compounding application will get rejected, saying that this is file part because there is a circular. Now 279(2) is the section which will say any offence either before or after the institution of prosecution proceedings can be compounded. This is what the section will say. Section will not say this is the timeline within which you should compound. 279(6) will say that with respect to these compounding petitions, necessary circulars or notifications will be issued. That circular will say that in case a prosecution proceeding is initiated against you, the compounding application should be filed within a period of 12 months from the end of the month in which the complaint is filed. This was further extended to 24 months, then subsequently to 36 months. Whereas if you sumo to realize that I have committed this offence, there is no time limit, you can compound the offence anytime. He filed the compounding application that was rejected, citing the timeline described in the circular. The court would have the authority would also gone one step ahead, saying that you are a habitual offender because for another year you have already compounded. So therefore you are committing the offence again and again. So therefore you will be treated as a habitual offender. I will not consider your application. Challenging this order, writ petition was filed before the Madras High Court. Madras High Court will say there are already other judgments. For candidates of Bombay High Court and both the judges of Madras High Court, Jayashree and Jay. There the court will say that a circular cannot go beyond a statute. The statute will only say you give the necessary guidance as to how a compounding application should be filed. When a timeline is not prescribed in the statute itself, a circular cannot go beyond a statute and prescribed timelines, which is not permitted. So therefore, the court in those judgments would have quashed the circular which prescribes the timeline. Citing that, even in the present case of Kabir Ahmed, the court will say that one, on the ground that this is rejected on timeline, that I am going to reject the argument, and two, you cannot say that he is a habitual offender because for that offence it is already being compounded. And there are certain categories that are generally provided when you want to compound an offence. Category A, B, C will be there. So whenever when a client reaches out to you saying that a prosecution proceedings are initiated, kindly look into the circular and see under which category your client is falling under. And the compounding guidelines will specifically give you 3 instances to compound an offence. Only if it is beyond 3 instances, they do have the power, provided they get approval from a higher authority. So therefore, as long as you fall under those offences that are provided in the compounding guidelines, you can definitely compound the offence. Now, because this prosecution is being taken up, it is becoming very regular in the recent past. So I think this also we need to concentrate. Tax practitioners should concentrate on this aspect. Now we will also deal with revision under 263 and finally conclude with the revision under 264.
As far as 263 is concerned, assessment order is passed. Now, assessment order may be in favor of the SSC for various reasons. Maybe the assessing officers were not inquired properly or something of that sort. And against the assessment order, the remedy that the department has, the CIT may invoke his powers, revisionary powers for 263. Now, this particular exercise of revision can be sought for by the commissioner if 2 things are satisfied. One, the order passed by the AO is prejudicial to the interest of the revenue, and that order is erroneous. It should be erroneous and prejudicial. Now, what are the scenarios or when can it be deemed that an order of an assessing officer is erroneous and prejudicial? Is if the order has been passed without making inquiries or verifications, allowing a relief without inquiring the claim of the SSE, order is not in accordance with an or say a direction or issued by the CPE. Order has not been passed in accordance with the decision. It is prejudicial to the SSE. Could be Supreme Court or High Court in the case of the SSE or the SSE as well. Therefore, it is for these circumstances that the CIT may exercise jurisdiction under 263 to initiate revision against the assessment order. Now, as far as the order under 263 is concerned, it is mandatory that this particular order has to be speaking order. He has to specifically mention and bring out the order as to how the order of the assessing officer is erroneous and prejudicial to the interest of the revenue. Say, for example, in the process that we saw with regards to what are these cases, if he feels that a verification has not been done, he has to duly specify as to what is the verification that should have been done and why the assessing officer obtained, and what is the case that has to be made out against the SSE which was not done in the assessment order. And the CIT must specifically establish the coexistence between the error and prejudicial and record category finding. Now, say for example, for a particular issue there are 2 views possible, and the assessing officer has taken one of the views. The CIT cannot initiate 263 proceedings when there are 2 views possible as far as one particular issue is concerned. And the time limit prescribed as far as the 263 is that it has to be order marked in 2 years from the end of the financial year in which the order sought to be revised is passed. 263 per se is a power given to the department to ensure that if at all an assessment order has been passed with few mistakes or so, they have been given the power at 263. And the order under 263 is appealable before the income tax appeal.
Unlike 264, where you gave your right for appeal.
She is just going to come. The last topic is
263 still can be appealed.
Yes. 263 order is available before the tribunal. Before 264, you have to surrender the right of appeal. Should be doing that.
Okay, so like you said, so 264 is generally preferred by an SSE when an order is passed, which is prejudicial to the SSE. This can be issued by the SSE or by the authority. Okay, both you can do that. So when you choose the 264 path, yes, you have to waive all your appeal remedies. And in case your 264 application gets dismissed, the only remedy that you have is to file a writ petition. So other than that, you will not have any remedy. So therefore, when you exercise the 264 remedy, you should be very cautious, and because you know in a writ, unless it has jurisdiction or natural justice violation, a writ petition will not be maintained. So if your 264 is dismissed on the ground with respect to your merits, then you will have no other option. So when you exercise 264, be very cautious. Now this 264 is there is a timeline given. It should be applied within a period of 1 year from the date on which you have received the order that you want to revise. So what are the powers that are conferred is it can give relief on issues which came even after the completion of assessment, can entertain new grounds which are not argued for the AO. So therefore the powers under 264 are very wide. So therefore, however, when you exercise that revisionary method, be very cautious as you are waiving of all other applicabilities. So yes, with this we come to the conclusion of the session. Any of you have any doubts?
So before going for appeal for the CIT case, CIT appeals also has the power to accept stay petition, right? CIT appeals can also apply, can allow petition, right?
Yes.
Demand
Yes.
stay petition.
Yes.
It is under what section, like what power, discretionary powers allowed to CIT, right? 251. Powers of CIT, discretionary powers. So rather than going to assessing jurisdictional assessing officer, we can directly go to CIT appeals, right? With the appeal form, right? Form 35, we can apply for condemnation.
Yes, you can definitely do that. Wherever you get a better.